The defendant, a 27-year-old who has elected to stand before the court, listens as the judge reviews the nature of the charge and the rights he is about to waive. "You are charged with injury to a child," the court informs him. "This is a third-degree felony. The range of punishment under the law, 2 to 10 years in prison and a fine up to $10,000. These words are not delivered as accusation alone. They are a legal mirror, reflecting back the potential future consequences of a plea. The defendant is told, explicitly, that by entering a plea, he gives up his right to a jury trial, the right to confront witnesses, and the right to remain silent. He is told that if he is not a citizen, immigration consequences could follow. The gravity is clear, the choice stark. His counsel confirms that the defendant understands the admonishments, that discovery has been reviewed, that defenses have been explored. For a moment, the air in the courtroom is strictly procedural. Lawyers, judges, clerks, performing the rhythms of law that ensure fairness. But beneath the procedure sits a human story. A person who has to decide whether to risk a jury's verdict or accept the certainty and constraints of a negotiated outcome. The plea bargain is presented. Under its terms, the punishment to be assessed is 8 years in prison, accompanied by a $1,500 fine. There is an affirmative finding of family violence. Conditions follow. No contact with specified individuals identified in the case file, and restrictions on residing with minors. The plea bargain, if accepted, will result in the defendant knowingly waiving his right to appeal, except for narrow, pre-trial written motions, and thereby foreclosing one avenue of future legal recourse, directly. How he pleads? He answers, no contest. A no-contest plea, in legal terms, means the defendant does not admit guilt, but will accept conviction as if guilty. It is a tactical choice, often made to avoid civil liability while resolving a criminal matter. It is also a choice that signals the end of one path, the contested trial, and the beginning of another, sentencing, accountability, and for many, a period of incarceration. The prosecution offers its evidence, a packet of exhibits, witness statements, and police reports. There is no live testimony. Instead, the state asks the court to accept stipulations, that witness statements and reports are reliable and sufficient to prove the elements of the offense. The defense consents. The court reviews the exhibits and finds, on that basis, that there is sufficient evidence to find the defendant guilty. This exchange is clinical. It is a legal shortcut that the system allows when both parties agree. But for observers, it creates a sense of unresolved questions. What happened to the child? What did the reports indicate? Why did the defense choose to accept a plea rather than test the evidence before a jury? At a later point, the defense requests a short continuance, a 3-week reset for sentencing, citing the defendant's need to arrange personal affairs. The court accommodates a brief recess, and then the room reconvenes for sentencing. There is no dramatic exoneration, no last-minute revelation that changes the course of the case. The hearing moves on to mitigation and argument. On behalf of the defendant, counsel asks the court to follow the agreed recommendation. The state asks for the sentence provided under the plea. There is little dispute on the factual record. The negotiation has already set the boundaries. The judge speaks. It is a moment that reveals the judiciary's dual role, interpreter of law and arbiter of the human circumstance before the bench. The court declares its findings. The plea was knowing and voluntary. Evidence has been reviewed. Stipulations were accepted. The court finds the defendant guilty and proceeds to sentence. The sentence is pronounced: 8 years in prison. Credit will be given for any time already served. A fine is imposed. The court records an affirmative finding of family violence. The conditions of the plea: no contact with specified individuals, no residence with minors, are made explicit. For the defendant, for the victim, and for the wider community, this is a definitive legal outcome, yet it is also an inflection point, a moment where law, rehabilitation, punishment, and social consequence collide. To understand the import of this moment, we must consider 3 separate but overlapping realities. The legal mechanics of plea bargains. Across American courts, the majority of felony cases are resolved through negotiated pleas rather than trials. Plea bargaining exists for pragmatic reasons. Court dockets are crowded, resources are finite, and certainty of outcome can spare victims and defendants the trauma of trial. But plea bargains also compress complex stories into single-line entries in a docket, often leaving public understanding incomplete. The consequences, immediate and long-term, of a conviction. An affirmative finding of family violence carries statutory and collateral consequences. Legally, it can bar the defendant from owning firearms, designate parenting limitations, and factor into future sentencing. Socially, it affects employment prospects, housing options, and familial relationships. The weight of 8 years behind bars extends beyond the physical cell. It reaches into the defendant's future identity and the stability of those connected to him. The human dynamics that the court must acknowledge, but cannot always remedy. The judge, while enforcing the law, may also urge reflection, rehabilitation, and therapy. The institutions of justice are not designed primarily to heal. They are designed to adjudicate and, where necessary, protect. Rehabilitation programs and therapeutic interventions may be recommended, but they are often contingent on correctional resources and the defendant's willingness to engage. In the minutes after sentencing, the judge addresses the defendant directly. The tone is conversational but firm. Whatever anger issues you have, the court says, you are going to need to internalize and find out what's going on with you. The instruction is practical. Domestic violence and the behavioral patterns that lead to it are often rooted in unaddressed mental health issues, substance use, or learned behavior. Court-ordered rehabilitation is one path to address these problems, but the judge is clear: change requires personal investment. The court reminds the defendant of the legal limitations that follow a conviction. No appeal except under narrow circumstances, restrictions on firearms, and prohibitions on residing in homes with minors. These are not idle restrictions. They are statutory requirements meant to safeguard vulnerable individuals and the public. But they are also lifelong parameters that color the defendant's re-entry into society. Outside the courtroom, reactions are mixed. For the family of the victim, for community members, and for advocates of child safety, the sentence may bring a measure of closure. For the defendant's family and friends, it is a source of grief and a reckoning with choices made. For defense attorneys and supporters of criminal justice reform, it is a reminder of both the scale of systemic constraints and the human cost of incarceration. No trial testimony was presented in open court in this case. No live witnesses took the stand. Instead, the court relied on written reports and witness statements, stipulations that the parties agreed were sufficient. This procedural choice is not uncommon. but it can leave public observers yearning for more context. A stipulation is a concession to procedural efficiency. It acknowledges the practicalities of adjudication, while simultaneously leaving narrative gaps. We cannot reconstruct every hidden detail from a single hearing. We are left, instead, to consider the pattern the record suggests: a young adult with a history that culminated in an offense affecting a child. Court advisements and plea negotiations that reflect the legal strategy of counsel. And a judge who, after evaluating the record, exercises statutory discretion to impose a custodial sentence within the agreed range. This case raises questions that reach beyond a single name or a single courtroom. How does society balance accountability with rehabilitation? When a crime touches a child, how do courts weight the need for punishment against the potential for transformation? How do plea bargains shape the contours of justice for victims seeking closure and for defendants seeking a second chance? Some will argue that 8 years is necessary for justice, a sentence commensurate with the harm alleged, the statutory range, and the need to deter future conduct. Others will say that incarceration alone cannot mend the social fractures that often precede such offenses: economic instability, untreated trauma, substance misuse, or fractured family systems. Both perspectives contain truth. The law seeks to impose consequences. Social policy seeks to address root causes. The two do not always align. The defendant's choice to plead no contest signals an acceptance of the court's authority without an explicit admission of guilt. For lawyers, this can be a pragmatic resolution. For victims, it can be a source of relief or frustration. The case ends without the sometimes painful public recitation of facts that a trial would require. For historians of the law, it's another data point in a system where the vast majority of serious cases are resolved quietly, without the drama of a jury's deliberation. Sentencing marks the end of this phase of the legal process, but it is not the end of the story. An 8-year sentence is also an opportunity for rehabilitative programming within the correctional system, for psychological evaluation, for accountability work. Whether that opportunity is seized depends on many factors: institutional availability, the individual's willingness, and the advocacy of supporters. The court's admonishments about post-conviction consequences are practical matters with emotional weight. The defendant is informed of restrictions on custodial rights, the inability to possess firearms, and the limitations placed on residence with minors. These are immediate legal consequences that will shape the defendant's reintegration into society. And there is the collateral reality: a criminal record will follow. Job applications, housing applications, and social perceptions will be filtered through the lens of a felony conviction. The legal system's finality, in many ways, is social and psychological as much as it is juridical. As the gavel comes down and the defendant is led from the courtroom, the recording clerk files the judgment. For those who watched from the gallery, prosecutors, defense counsel, family members, and the public, there is a moment of quiet. The legal process has fulfilled its immediate purpose: adjudicate, sentence, record. But the questions linger. What will life look like 8 years from now for those involved? For the victim, for the defendant, for the families whose lives intersected in this case. The sentence will set a trajectory. Time in a correctional facility may be punitive, but it can also be transformative if the institutions and the individual commit to change. This hearing also serves as a reminder of the limits of courtroom narratives. A transcript captures words and procedures. It cannot capture the internal landscapes, the history of relationships, the systemic poverty, or the private trauma that often animate courtroom conflicts. The law requires evidence. Society requires empathy. Where they meet, or fail to meet, is where stories like this unfold. In the end, this was a plea, a verdict rendered, and a sentence announced. The courtroom moved on to the next matter on the docket. The judge's admonitions, practical, stern, and occasionally personal, became part of the legal record. The defendant will serve a period of confinement shaped by state policy and by his own choices. The victim may find solace in a sense of accountability. They may also continue to heal outside the framework of legal remedy. For viewers and listeners who engage with cases like this, the takeaway is complicated. The law demands both the protection of the vulnerable and the fair treatment of the accused. It asks society to weigh consequences and to invest in prevention. It asks individuals to take responsibility for conduct that harms others. None of these tasks is simple. None is solitary. This case, like many others, will become a part of official records, a line in a docket, a page in a criminal history. But it will also persist in memories. The voice of the judge, the defendant's quiet assent, the stipulations accepted, the sentence pronounced. Those elements, when strung together, reveal as much about the system as they do about the people inside it. We are left, finally, with the human question that underlies every courtroom drama. What does justice require, and what does justice allow? The law offers rules and remedies. The community offers support and judgment. The individual must face the consequences and, if possible, find a path forward. This has been an account of one plea hearing, told in sober terms and grounded in procedural fact. It is not an exhaustive portrait of the individuals involved, nor a final pronouncement on their lives. It is, instead, an entry point, a moment of law made real, where statute meets consequence, and where human lives are forever rearranged by the decisions made inside a courtroom. If you found this account illuminating, consider subscribing for more investigative court stories that explore the intersection of law, society, and human consequence. Until next time, this is a reminder that behind every docket number, there are people, histories, and futures.